can proceed now. I would like to invite Honorable Judge Arthur Bayarsa to the podium, where he is going to speak about the new AIA and related to the litigation strategy, starting from the new law from the Patent Office.
Good afternoon, once again. I'm going to be discussing the American Invents Act, which was the new patent act that was enacted by the Congress after almost 11 years of negotiations, and the AIA, as it's known for short, is necessary to be understood if you're going to litigate in the patent area in the United States. It has a definite impact on litigation because of many of its sections which will allow people to challenge patents in the Patent Office instead of the courts. The important provisions of the Act are several. It changes American law from first to invent to first to file. In other words, if you are the first one to file in the Patent Office, you're entitled to a patent, which essentially is a standard in the rest of the world. So the United States has finally joined the rest of the world in the first filing. There are several deviations from that. However, because I want to get to the issue of patent litigation and how it might have impacted the Samsung-Apple litigation, hypothetically, it's important to look at some of the issues very peripherally. The fee-setting authority is given to the director, and some of the fees are rather strong, in the thousands of dollars. The Act also prioritizes examination of certain inventions. You can pay for moving up in line before the Patent Office, so you don't need to change the aspects of the particular waiting in line for your turn to be examined. It changes the inter partes re-examination process. It changes the supplemental examination. It also changes and issues a post-grant review, which essentially obtains for third parties the possibilities of changing the aspects of re-examination before the Patent Office. The next item is the inter partes review, which has changed. It changed to the best mode requirement, which is a disclosure as to how to exercise the invention in the best way. What used to be a defense in patent litigation is no longer available. You must disclose the best mode, but a patent can no longer be invalidated for reasons of not disclosing the best mode. And you also have a pre-issuance submission by third parties, which means that a third party can submit prior art during the examination of a patent before the Patent Office. a third party unrelated to the patent applicant. Oops. The provisions became effective at different times. When the act was signed by the President on September 16, 2011, there was a fee-setting authority which became effective. The best mode authority became effective, and virtual false markings. The 12-month period from enactment, which was September 16, 2012, it brought in inventors' oath declarations, third-party submissions of prior art for patent applications. As I said before, you now have the ability to bring in prior art during the examination of a patent application. Priority examination for important technologies was effective on that date, meaning that if you pay an additional fee, you move to the front of the line. Inter-parties review became effective at that point in time. Post-grant review, which is a PGR, it's called. In Washington, we like to use initials for particular sections of the statutes. So that's why you see IPR and PGR. Then there's a transitional post-grant review program for covered business method patents. Business method patents were challenged during the process of legislation, and there's a transitional review for some of those patents before the Patent Office. Supplemental examination means that a patent owner, once the patent is issued, may request supplemental examination of a patent to consider, reconsider, or correct information believed to be relevant to that particular patent. The reason for this is quite clear, that if a patent owner finds additional prior art or knew of additional prior art which was not raised during the prosecution of the particular patent application, can bring it up after the patent is issued. The principal reason for this is that if a patent applicant knew of prior art and did not disclose it to the Patent Office, he or she could be charged with inequitable conduct. The inequitable conduct charge could invalidate the patent if proven in court. So this particular procedure allows a patent applicant to be able to inoculate that particular patent from a charge of inequitable conduct, which is very, very critical, because in the past, one of the defenses that was raised in most patent infringement cases by defendants was the allegation of inequitable conduct. If that was proven, the entire patent was invalidated. So this procedure allows the patent holder to avoid that particular invalidity defense, which is also tied into fraud on the Patent Office. Fraud means basically that you knew of some position or some disclosure which was not made to the Patent Office, and you continue to obtain the patent in spite of that particular position. The new requirement means that it must be filed by all the owners. If there's more than one owner of the patent, all must join in the subsequent supplemental examination. And the supplemental exam is not the same as the ex parte review or post-grant review, the PGR that I mentioned before. Supplemental exam is by the patent owner and not by a third party. Now, this is the important part. The new act provides 2 post-grant reviews of patents. The first one is called inter partes review, and this is a basic strategic change to the patent laws in the United States. As of September 16th, 2012, the inter partes examination is replaced by inter partes review, and it's adjudicated before the patent office. That patent trail should be patent trial and appeal board. That's a typo. The specific provision allows for judges, administrative law judges, which are patent office employees, sitting in panels of 3s to review the subsequent examination of a patent, a challenge. It applies to any petition filed after September 16, 2012 of last year, of this year, just recently, and both to first to invent and first to file patents. This particular procedure is already being used by some of the major companies in the country. Microsoft has filed some actions before the patent office, and so is Google, challenging a number of patents. The petitioner in those particular proceedings can only raise grounds under 35 U.S.C. 102 and 103, and only on the basis of prior art consisting of patents and printed publications. Any third party may petition if they have not previously filed a civil action challenging the validity of the claims. This means that if a particular defendant or a potential defendant knows of a patent that may be asserted against his company, he has 2 routes to follow. If he has standing, he can bring a civil action in federal district court as a declaratory judgment action against the patent holder challenging the validity of the patent. Or, as a new law provides, he can now challenge that particular patent in the patent office. The trial will be held in the patent office based upon information which he has found, printed information, prior art, and that case will go forward before 3 judges at the patent office. The ruling under the statute and the regulations would be issued within 12 to 18 months, which is a much quicker route than you would obtain in the federal district courts in most cases. If you have a favorable decision by those 3 judges, the patent can be held invalid. An unfavorable decision either party receives can then be appealed to the federal circuit. This particular action can only be brought 9 months after the issuance of the patent. So there's a time limit. You cannot bring it within 9 months of the actual issuance of the patent. And in the motion to amend after the institution, you only get one chance to amend it. And the last item is that the proceedings must be completed within 1 year from the institution. However, as you well know, litigation sometimes does slip even before the patent office, and that 12-month, 1-year limitation will most likely be changed to 18 months. Now, that's one process which has to be kept in mind if you're litigating the patents after September 16th of 2012. The second route that can be taken, and this only applies to first inventor to file patents, and that particular section of the statute takes effect only after March 16, 2013. The reason for those various dates is to allow the Patent Office to issue internal regulations impacting all of these procedures. The PGR, as it's called, allows challenges to any patent issued after the first to file date based on sections 101, 102, 103, and 112, except the best mode. It must be filed within 9 months of grant or issuance of a reissued patent. It also has a higher threshold than the other proceedings that I just spoke about, the IPR, that at least one of the claims of the challenge patent is not patentable. There must be a reasonable doubt as to the validity of one of the claims at least. And as you can see at the bottom, the fee, the filing fee before the Patent Office to challenge up to 20 claims, whether it's 1 or 20, is $35,800. Very steep fees for some of these procedures. However, if you're in litigation, you have to take both of these processes into account. In the Apple v. Samsung proceedings, for instance, if this statute was passed before that lawsuit was filed, the defendant could have challenged the patent before the Patent Office instead of the courts. This is why it's critical to understand the new process under the American Invents Act. The new act provides different avenues and different strategies for patent litigation in the United States. The Patent Office has issued regulations impacting the procedure for all of these processes, and those regulations were issued, the last ones were September 11th, 2012. They're very extensive, very complicated, but from a strategic standpoint, it's important to understand that the level of litigation in the United States for patent cases has changed. The strategy that has to be taken into account is whether you wait to be sued as an infringer, or you challenge those particular patents that you might be asserted against you in the Patent Office. So you now have more than one route to undertake And the question becomes, what are the probabilities of challenging the patents before the Patent Office versus challenging the validity of those particular patents in the courts? There are different burdens of proof that have to be taken into account. And those burdens of proof can also indicate whether you follow the PTO's route or the federal court route. Now, there are a lot of similarities between the PGR and the IPRs, but they're effectively the same process, except that the PGR has the ability to raise many of the defenses that you cannot get in the IPRs. The IPRs are limited to prior art, patents, or publications, while the PGR, you can file just about every item of evidence that would invalidate the patent before the Patent Office. It will be a trial before the Patent Office, before a board of 3 judges. You have discovery proceedings, which are covered by the rules at the PTO, limited in many respects, more so than you would have in the federal courts. They did not parallel the discovery proceedings in the federal courts. You do have some limited discovery of depositions and witnesses. Witnesses can be brought before the panel of judges. And the panel of judges that you have at the PTO are usually experts in the patent law, which is one factor that you might want to take into account when you're trying to decide which road to pursue in litigation, whether you're attempting to defend in federal courts or in the Patent Office. Thank you.
Thank you, Judge. You raised a really interesting point where the patent owner could, or a legitimate infringer can use the USPTO as a second-tier forum to defend yourself or protect the undervaluing to the issue of validity. So now it's time to move on to the European practice inviting Senor Miguel Rato from Belgium.
Gracias, Senor Ha. Good afternoon, ladies and gentlemen. What I'm going to try to do today is give you just a brief overview of the non-technical defenses that have been raised in the Samsung Apple proceedings. So meaning all those defenses that are unrelated to issues of validity, infringement, etc. Just to recap briefly, obviously you all know that this is a global dispute between 2 of the leading smartphone sellers who are at the same time IP owners, and it encompasses United States, a number of countries in Europe, South Korea, Japan, Australia. Patent infringement proceedings have been launched by the 2 parties in these jurisdictions. Each accuses the other party of IP infringement. So Samsung has been asserting against Apple standard essential patents, and Apple has been asserting non-essential patents against Samsung. So essentially design rights, etc. Each party has sought injunctive relief and or damages against the other. To make matters more complicated, in addition, there are 2 antitrust investigations launched by the regulators in the United States and in Europe. These investigations concern primarily Samsung's conduct. The European Commission has announced that it is investigating whether, by seeking injunctions in national courts in relation to the alleged infringement of its standard essential patents, Samsung has infringed EU competition law on abuse of dominance, also known as Article 102. And it should also be noted that the Commission has launched a parallel proceeding looking into whether Motorola's conduct with regard to amongst others, Apple and Microsoft, could also constitute an abuse of a dominant position. Now, as I've said, Samsung has asserted standard essential patents. I'm going to try to give an overview of the FRAND-related defenses and the antitrust-related defenses that have been raised by Apple. And obviously, this brings us to the question of what is standard setting, what are standard essential patents. It's well known that standardization is essential to the success of so many industries. It is fundamentally pro-competitive. Standards allow products to interoperate, to communicate, to interact. Most important standards are agreed in formal standard setting organizations or processes. These include, for instance, the European Telecommunications Standards Institute, ETSI, the International Telecommunications Union, ITU, and these standard setting organizations usually ask the participant companies which contribute technology to the standardization efforts, first to make a declaration stating that they believe they have intellectual property that will be potentially essential to the standard, meaning that it will not be possible to implement the standard without infringing that IP. And secondly, they are asked to commit before the standard is adopted that they will license their IP that will be found to be essential to the standard on fair, reasonable, and non-discriminatory terms. Now, importantly, the SSOs will not determine whether any IP that has been declared as potentially essential is actually valid or that it is indeed essential to the standard. Now, what is the FRAND commitment? I've tried to set out here what it is, and by contrast, what it is not. A FRAND commitment is a contractual commitment, and its content will vary, because it is contractual, from SSO to SSO, and also presumably over time. So it will depend on the specific rules of the standard setting organization in question. It is a commitment that the patent owner will enter into good faith negotiations with a prospective licensee to achieve the goal of concluding a license on fair terms. It is an open and a flexible concept that can be tailored to a broad range of circumstances, that can be tailored to fit the different needs of a patent owner and an implementer of the standard, although it is binding. What a FRAND commitment is not, and this has been argued by numerous parties in litigation over the last few years, is a creation of statute, of economic theory, a creature of public policy. It is not in itself a license agreement. It is not an offer to license that can be accepted by simply implementing the standard, as a result of which the only thing left to determine would be a price. it is not a commitment to grant a perpetual license, and it does not entail necessarily a waiver of the right to seek injunctive relief for the patent owner. Now, Apple has raised a number of defenses based on the friend commitment that it has opposed to Samsung in litigation. So Apple has sought to avoid injunctions by arguing first that under applicable French law, the friend commitment had already had already resulted in a license. So the commitment was an offer to license, and it was accepted by Apple simply because it started to implement the standard. Now all Samsung could get would be a court to determine what the price, meaning the royalties, should be. Well, Apple has had very little success with this line of argument, and courts in Europe have held that friend commitment is not an offer that is capable of being accepted without further negotiation, and instead that the friend commitment entails a bilateral duty to negotiate in good faith. Second, Apple has argued that by giving a friend commitment, Samsung had waived its right to seek injunctive relief. In other words, it could not, under any circumstances, obtain an injunction. Again, this has been this has proved not very successful for Apple. Courts have held that the implementer of a standard can expect to conclude a license on friend terms following negotiations, but in principle, the patent owner who has given a friend commitment is not prevented from enforcing its IPRs and obtaining an injunction in specific circumstances. And in particular, the Etsy friend commitment does not imply such a waiver. The third argument that Apple has raised is that Samsung has engaged in some form of patent ambush because it only disclosed some of the patents that it had asserted to Etsy after the standard had, or one set of specifications had been adopted. Again, this is, Apple has had very little success with this friend defense, and courts in Europe have noted that Samsung gave a blanket commitment in 1998 that it will license any patents that were found to be essential to the standard on friend terms. Fourth, and here Apple has been more successful, it has argued that in the specific circumstances of the case, it would be a misuse of rights or inequitable for Samsung to enforce its patent rights against Apple. And the courts have looked into the history of negotiations to examine whether both parties had acted in good or in bad faith. So the courts have looked at Samsung's conduct and have looked at Apple's conduct and have also looked at a number of other elements, and they have reached different conclusions depending on the jurisdiction. But for instance, the court in the Netherlands concluded that Apple appeared to have negotiated in good faith, but that Samsung did not appear to have made a good faith offer, as a result of which an injunction was denied. By contrast, the court in Italy found that Samsung and Apple appeared to be negotiating in good faith. In that case, a preliminary injunction was rejected, not on those grounds, but as we shall see, on different grounds. And so the different ground is an argument that is only partially related to friend. Apple argued that Samsung's rights were exhausted and that Samsung could not assert them against Apple. This is one of the arguments that was accepted by a court in France and also in Italy. Why were the rights exhausted? Well, Apple relied upon agreements that had been concluded on the one hand between on the one hand Samsung and on the other hand chip manufacturers Qualcomm and Intel. And Apple argued that under the terms of those agreements, when Apple used a chip sourced from Qualcomm or from Intel in its products, the rights that were granted by Samsung to Qualcomm or Intel effectively flowed to Apple as a chip customer of those companies. One of the elements that the courts have had to consider also has been the fact that in the Samsung-Qualcomm agreement, there's a condition that the third party seeking benefit of the provision, giving rights to the chip customer, did not bring an action against Samsung. This is known as defensive suspension mechanism. Apple argued that Samsung's reliance on this provision was against the irrevocability provisions of the Friend IRC declaration. It has had some success with this argument, notably in France and the Netherlands, where courts have concluded that the IRC Friend commitment is irrevocable, but that also a license granted under the Friend IRC commitment is irrevocable, and therefore that Samsung could not invoke a defensive suspension mechanism to prevent Apple from obtaining the benefits of the cross-license Samsung had granted. In my view, this is an incorrect interpretation of the IRC Friend commitment. The commitment itself is irrevocable. The license should not be irrevocable, and indeed courts have concluded that the license is not irrevocable because in many circumstances, it can be terminated. So, for instance, where the licensee does not pay the royalties due, and therefore there has to be something else here. Which the court should be looking into more carefully. Now, turning to the antitrust arguments, the first set of arguments were friend-related, but not purely antitrust. The antitrust arguments are separate from the arguments based on contract or on misuse of rights. And in the context of the enforcement of standard essential patents, they usually include the following elements. The first element is an assertion by the defendant that each standard essential patent constitutes its own relevant antitrust market, and therefore, because it has a monopoly in that relevant market, that market limited to one single standard essential patent, each patent owner is necessarily dominant. Now, this is absurd, because if you equate the possession of ownership of an essential patent with dominance, this would lead to the absurd situation that you have thousands of dominant positions held by numerous companies. There are hundreds of thousands of patents in a smartphone. Would that mean that every single owner would be in a dominant position? And if two companies are, two patent owners are negotiating, they would be both in a dominant position, which conceptually, makes no sense. In any case, there can be no dominant position until the patent is held to be valid, essential, and infringed, and this requires a fact-specific assessment. The second is an assertion that behavior or licensing terms that are not friend are also anti-competitive. Even assuming dominance to be incorrect, you assume that that conduct that is inconsistent with a friend commitment is also anti-competitive. Antitrust courts and authorities must apply the proper legal standard to the conduct under investigation. In addition, it is not clear that any antitrust intervention will be required, as courts are well placed to deal with friend disputes using traditional tools. On the antitrust theories of harm and the proper legal standard, there is very little case law. I've cited two cases that are not enlightening. The allegation that line terms are not friend has been framed in the following manner. If licensing terms are not friend, they are excessive, and therefore you should apply the legal standard that prohibits excessive pricing under EU competition law, known as the United Rates test. This is an outdated theory that has not been applied in 30 years. More importantly, the proper test is one that deals with refusal to license IP, and which establishes that only in exceptional circumstances would a refusal to license IP or a proposal to license IP on certain terms could be considered an abuse of a dominant position. It would require the indispensability of the IP, that it would prevent the emergence of a new product for which there is a potential customer demand, and that the refusal or the terms would eliminate all competition. So a very demanding test. The second theory, which is the one being pursued by the Commission, is that simply by bringing request for injunctive relief, Samsung would have engaged in vexatious litigation, that this would be abusive. The legal standard under EU competition law is a case called ITT Pro Media, has been reaffirmed very, very recently. It sets an extremely high bar because it states that access to the court is a fundamental right and a general principle that ensures the rule of law, and therefore that it only in exceptional circumstances that the fact that legal proceedings are brought is capable of constituting an abuse of a dominant position. And an action can only be abusive if a two-pronged cumulative test is satisfied. The action must be manifestly unfounded, meaning that at the time the action would be brought, it cannot reasonably be considered as an attempt to establish the rights of the company and can only serve to harass the opposite party, and the action is conceived in the framework of a plan whose goal it is to eliminate competition. So a very, very high hurdle. My view is that given what we know from the record, in the cases that have been litigated, it's highly unlikely that by relying on this case, the Commission will be able to conclude that, or to bring a persuasive case that Samsung has abused the dominant position. Because I only have 2 minutes, I will skip and finalize with a few policy considerations regarding the danger of over-intervention by antitrust authorities. It is dangerous from an economic perspective, and it is dangerous from a legal perspective. Focusing on the legal perspective, intervention would distort the very nature of IPR. A case similar to the investigation by the European Commission could undermine fundamental right of access to courts if it would be found that to ask a court to grant an injunction is abusive. And finally, that any attempt to change these tests in favor of other theories threatens to undermine legal certainty in a critical area of the economy. Thank you.
It seems to me that everything has a need to consider about the issue of balancing good to bad and benefits and costs and then any other economies and legal perspective. Those kind of issues are always competing each other. So now we'll move on. We need some special integrated IT policy to survive in these IT war era. So I'm going to invite Eric Wright Schneider, who's a senior vice president, general manager of licensing firm of Qualcomm. He's talking about the IT strategy of a global IT company.
Thank you. So I have good news and bad news. Good news is I have the privilege of being here today to talk to you about the subject of IP strategies of global companies, which is a topic I think is very interesting and also very timely. Bad news is I only have 20 minutes, so I'm going to have to talk fast, so I hope the translators have their seatbelts fastened. Now I have to start off with the disclaimer. Most strategies are inherently better if they're kept secret. So for those of you who might have come here today hoping I was going to reveal Qualcomm's IP strategy for the next 10 years, I'm afraid you're going to be disappointed. Instead, I'd like to talk about this topic in a more general way. I'd like to begin by talking about how patents are the centerpiece of the IP strategy for any global technology company these days. Why that's the case and whether that's a good thing or a bad thing. And for those of you who don't like to be kept in suspense, I'll give you a hint. I'm going to make the case that it's a good thing. Now, in doing this, I'm going to try to point out what's new compared to 30 or 40 years ago, and what's not so new. And finally, I'll talk about the different kinds of IP strategies for global technology companies that have evolved over the last few decades. And I'll talk about one recent development that has had a large impact on how those strategies operate. Just a little bit about my personal background. Before I joined Qualcomm earlier this year, I was for many years an IP transactions lawyer in large US law firms. My clients included venture-backed startup companies and Fortune 100 giants in semiconductors and hardware, software, internet, e-commerce. And so my perspective on this subject is shaped not only by my knowledge of Qualcomm's IP licensing business, but also my experience in working closely with technology companies, large and small, and helping them buy, sell, develop, license, and otherwise commercialize intellectual property for many years. As I'm sure many of you know, patents are not the only form of intellectual property. In the United States, for example, there are also copyrights, trademarks, and trade secrets. And that's true in other countries as well. But patents are by far the most important form of intellectual property to any large multinational technology company. If you doubt that's the case, just consider how much money is spent on obtaining patents and on litigating over patent rights. Now, I don't mean to suggest that other forms of intellectual property are not important. Certainly they are. They're important not only to technology companies, but also to companies in other industries. In other industries, they may be more important than patents. But in the tech world, patents are king. And why is that? Well, copyright protects expression, but not ideas. Trade secrets have to be kept secret, or else they lose their value. Trademarks just indicate the origin of a product, but not how it works. Patents are harder to get, and they don't last as long. But what they give you is a very powerful right. They give you the right to stop somebody else from making, using, or selling a product that's based on your invention, whether or not they knew you had the patent, whether or not they ever had access to your technology, whether or not they ever copied anything. It's a very powerful right while you have it. And you have to understand that technology R&D is a very risky business. To come up with a real breakthrough, or even to come up with something that's really a significant improvement over something that has already been developed by someone else, it's not easy. And it's even harder to do it before anyone else has done it. So in fields such as computing, electronics, semiconductors, telecommunications, that are entirely based on advanced technology, the ability to get the strong rights that a patent affords is crucial. It's absolutely crucial to get people to devote their educations, their careers, and their money to investing in what you're doing as opposed to something else. Don't just take my word for it. Take a look at the increase in patent filings over the last 30 years in different fields. What we show here on the chart is patent filings in computer technology, telecoms, pharmaceuticals, and machine tools. And what you can see is there's been a dramatic increase in computer technology and telecoms, and hardly any increase at all in machine tools. This is a trend that's not by any means limited to US companies. In fact, of the top 10 companies in terms of US patent filings last year, only 2 were US companies. Number 2 on the list, as you can see, was a Korean company, Samsung. Now, the dramatic increase in patent filings over the last 20 to 30 years in these fields has caused some people to complain that there are too many patents now. There are several things I think you should keep in mind when you hear these complaints. The first is this: it should not be in the slightest way surprising that there are more patents now. Not once you take into account how much more inventing and innovating takes place every day around the world compared to 30, 40 years ago. How many of you know what Moore's Law is? Raise your hands if you've heard of Moore's Law. Okay, not that many. All right, so I'll put this in terms, hopefully, that you'll relate to a little bit better. To me, it's nothing short of miraculous that with just a few clicks on my laptop, I can have access to virtually everything that's ever been written and published in the history of the world. And it's nothing short of miraculous that just by pushing a few buttons on my cell phone, I can instantly have a live conversation or even a video chat with someone on the other side of the world. I mean, this was the stuff of science fiction 30, 40 years ago when I was growing up, and now it's real. I was a physics and math major in college, and like I said, I've worked with lots of entrepreneurs and executives and engineers in technology companies. And so maybe I can appreciate a little bit more than other folks, you know, what it takes to make all this happen. It takes a lot more than that one big sort of aha moment that they like to make movies about or write books about. It takes large teams of highly educated, dedicated professionals working for months and months and months and years and years and years, trying to solve a host of problems that seem impossible to solve at first. And they spend a lot of time working on different ideas and solutions that end up not working at all until they finally figure it out. And you know, I get the sense when I hear some people talk about how there are too many patents out there that they just don't understand that. Usually what they're talking about, though, or complaining about, is not that there are too many patents, but that there's too much patent litigation. I mean, after all, who likes patent litigation? But you have to stop and ask the question, is there really a global epidemic of patent litigation, the likes of which we've never seen before? Well, the answer is no, not when you step back and put things in a historical context. And sophisticated and thoughtful people like the head of the US Patent and Trademark Office or the CTO of Microsoft recognize this. The so-called smartphone wars are hardly the first time there has been a wave of patent litigation over a new disruptive technology. One of the first so-called patent wars centered on the sewing machine, believe it or not. The sewing machine wars took place in the 1850s. That was before the Civil War. That was before Abraham Lincoln was president. That was when there was still slavery in the United States. That's how long ago that was. And it was headline news, front page news in newspapers in the United States. Litigation went on for decades, and it was finally settled by the formation of what I think was the first patent pool. You know that old saying, there's nothing new under the sun? Well, it's a good saying to keep in mind here. Now, it's true that the overall number of patent lawsuits has increased over the last 20 to 30 years, but that increase has been proportional to the number of patents. In fact, there was an article recently on the web, I just saw it today, written by the Chief Patent Counsel of IBM, and it refers to economic studies that show that there was more patent lawsuits per patent in the 19th century than there is right now. A very small percentage of patents actually get litigated. So the fact that there are more patent lawsuits now, again, nothing unusual or surprising or alarming about that. The other thing to remember is that the vast majority of patent lawsuits are settled. I think it's well over 80%. Case in point, Apple and HTC just a few days ago announced the settlement of their lawsuit. A few years ago, Apple and Nokia settled their litigation after going at it for a while. Samsung and Microsoft entered into a cross-license without ever having to get involved in litigation in the first place. The smartphone patent wars will end. The cases will settle, it's just a question of when, and everybody will go on with their business. So I think really there's scant evidence, if there's any evidence at all, that the increase in the number of patents around the world has caused any sort of litigation crisis. On the other hand, there's ample evidence that over the last 20 to 30 years, during the same period of time that the number of patent filings was increasing so much, there have been really incredible advances in technology that have led to hundreds of millions, even billions of people having access to the kinds of products that we all take for granted now, but that are really, as I said earlier, quite miraculous. Take the wireless telephone, for example. I worked for Motorola for a short time back in the mid-90s at their headquarters in Illinois. And back then, what you got when you worked at Motorola was a pager, a two-way pager. And we all thought that was really neat. What a great way to stay in touch with your colleagues. Not so great when your boss wanted to track you down, but otherwise kind of a cool thing. The point is, Motorola didn't give out cell phones to its employees, you know, in 1995, 1996. Just a few years later, though, cell phones were widely available. And it wasn't too long after that that RIM came out with the BlackBerry, and we all started doing email on our phones. And it wasn't that much later than that that, you know, we have smartphones and we surf the web and manage our stock portfolios and download books and movies, and you know, take photos that are better than what the best digital camera could have done not that long ago. And the same technology that makes all this possible. And by the way, they're called smartphones for a reason. They're not called handheld computers. They're called smartphones. They're phones. You know, the value is largely in the fact that they work just about everywhere. One good way to recognize that is compare the price of an iPhone to the price of an iPod Touch. You know, it's basically the same thing, except the iPhone has that wireless communications ability, you know, where it works anywhere and you can use it as a phone. If you don't know, I'll tell you the answer. It's $450. That's the difference. It's the majority of the price of the product is that long-range wireless capability. And that technology is now being put in cars, vending machines, utility meters, other kind of products for the first time. It's really amazing. And again, the increase in the number of patents and the increase in the number of patent lawsuits hasn't stopped any of that from happening, and it certainly hasn't stopped Apple and Microsoft from becoming two of the wealthiest and most profitable companies in the history of the world. So, you know, just the opposite. It seems pretty clear to me that this would not have happened without patents. I've seen firsthand how important patents are when a venture capital firm is deciding whether or not to invest in a small company, or when a large company is deciding whether to acquire a small company. If you have good patents on your core technology, it really improves your valuation. And on the flip side of that, if somebody else has a patent that you need to use and you don't have a license to it, that can really hurt your valuation. It can even kill a deal. In that article I mentioned earlier that the Chief Patent Counsel of IBM recently wrote, it's up on the web, and I'll be happy to give you a link to it later if you send me an email and ask me for it. Again, it cites economic studies that show that 75% of the value of a company is attributable to its intellectual property. The real-world evidence also shows that the prices for products in the tech sector have gotten lower and lower over time, and now they're affordable to just about everyone around the world. I mean, that's amazing when you think about it. Don't we all wish that had happened with cars? Well, maybe not, actually. Traffic's kind of bad enough as it is. You know, last year I took my family on a trip to Africa. It was the first time I had gone to Africa. And as we drove through the countryside in Kenya and Tanzania, we saw lots of villagers and Maasai warriors walking along the road with their cows and their goats, taking them to market. And so many of them had cell phones. Not the cows and the goats, the villagers and the Maasai warriors.
Very good.
Okay, it was really amazing. Korea is a good example of how a solid IP system can support commercial growth. So most large technology companies these days are global companies. So it shouldn't come as any surprise that the starting point of having an IP strategy is to have a strong global patent portfolio. Having a US patent doesn't really stop somebody from attacking your supply chain in Asia or selling a competitive product in Europe. And if you look at the patent filings of major Korean, Japanese, and European tech companies over the last 20 years, you get a sense of this. This chart shows how patent applications have ramped up not only in the United States, but also in Japan, China, in Europe, and Korea. So once you've built up a strong global patent portfolio, the next question is, what do you do with it? Well, there are many different strategies. One strategy is just to use your patents defensively, sort of a deterrent to someone else suing you for patent infringement. You don't license your patents except if you're doing a cross-license to settle a case. This was the practice in the semiconductor industry back in the 80s and early 90s, by and large. Another strategy is to use your patents offensively, to try to block your competitors from coming out with new products and gaining market share. When you have an offensive strategy, you still don't license your patents very much. You want to keep them to yourself and use them as strategic weapons, so to speak. And this is what was done in the microprocessor industry and the EDA design tool industry in the 90s when consolidation was taking place and large companies were battling it out for market share. Starting in the 90s, though, another strategy began to emerge, and IBM was one of the first companies to do this, and that is using patents as a source of revenue. Some companies, like ARM and Rambus, decided that licensing was the way to go entirely and didn't even try to make products based on their patented technology. Other companies like Qualcomm do both. We have both a patent licensing business and a product business. The number of patents has increased a lot in the last 20 years. Something else that's increased a lot also is standardization activity. Companies coming together and working collaboratively to develop industry standards so that their products can be compatible with one another. There are now dozens, if not hundreds, of industry organizations that provide the environment for companies to do this. If you're going to have a global patent portfolio and also do a lot of standard setting, though, you have to really think carefully about how you're going to do that. You have to think about how you comply with the disclosure requirements, disclosing patents that you have that may be essential to the standard, and you have to think about the impact it will have on your licensing program if you want to have a revenue-generating licensing program. I don't have time to go into that more, unfortunately. I'd be happy to talk to you later on if I get a chance. Let me just close with this. Because there's so much standardization these days and so many patents essential to industry standards, you've seen or heard other people talk about how there are thousands and thousands and thousands of patents, you know, on a given smartphone. Some people complain that, well, there's no precise definition of friend, and that causes a problem. Now, these tend to be the same people who complain about there being too many patents and too much patent litigation, for what it's worth. And again, I'd ask you to keep just a couple things in mind when you hear these sorts of complaints. 30 seconds. All right, two things. One, essential patents are just as important to incentivizing companies to do R&D and make big bets in technology as any other kind of patent. And if you change the rules for essential patents and devalue them and make them not as good as other patents, you're going to change that landscape. And you're going to make companies not want to invest in much in developing certain kinds of technologies or in contributing their technologies to standards. And over the long run, obviously, that would mean standards based on inferior technology. That's a bad thing. And secondly, all the evidence is that the existing FRAND regime has actually worked very, very well. You know, again, that evidence is how how many people in the world have cell phones, smartphones, access to the internet. So much of that happened, you know, during the regime that some companies are now complaining about. It's kind of ironic that the companies complaining about are the ones who are able to enter these markets because of FRAND systems and standardized technologies that they're now taking advantage of. So keep that in mind when you hear these types of complaints. Thank you.
And I was about to tell you that we have 5 seconds. Yeah, it is clear that the global large size companies are going to use their key assets such as intellectual property, right, to maximize their property, whatever leverage they have through in the form of litigation or licensing. They